Good morning and welcome to our public safety webinar. We are located here at 3010 East Camelback, and we have a group that's in the webinar as well, and we welcome that group as well. So we're going to have participation all day long for 2 or 3 hours, and you can stay on the webinar as long as possible. We'd love to have you ask your questions. We'll get those answered as we go through the process. We'll stop at certain points of the webinar and the presentation today to make sure you understand all of your questions will be answered today. So what I'd like to do is start off with introducing myself. My name's Don Minear. We're here with Public Safety Personnel Retirement System. We're going to talk about first the duties and responsibilities of the local board for both correction officers, board members, and public safety board members today. During our presentation, we have a few objectives we'd like to follow. And the first one is, why do we need a local board? Why is it needed? And that's always a question that comes up. We'll just say 250 local boards around the state of Arizona. They're all 5-member boards. They all communicate back to our office, and we'll get into that process as well. What is the composition of the local board? Who should be sitting on the local board and why, and what is the importance of that? We'll also be talking about local board duties and responsibilities, a little closer look at those so you can make sure you're following the rules and making sure within your jurisdiction that you're making good, prudent decisions. And things to consider going forward. So if there's no other questions at this time, we'd like to go ahead and get started and say, why do we have local boards? What do the statutes say? So let's just throw that question out to the group that's here or on the webinar. Why do we have a local board? Does anybody know why? Why do you have a local board, a 5-member board?
To present the retirements.
To present the retirements. That's a good reason. You determine the retirement benefits. That's right. And what we want to do is go through specifically what the board's supposed to do and make sure those retirements get approved. So one of the reasons for the local board is the administration of the system and the responsibility for making provisions for each employer vested in that local board. In other words, you represent the local board, the employer, on the end of those who are retiring. Our office is just a clearinghouse to approve those payments and review the calculations, and then you as a local board make all the determinations and calculations, but we just review it and approve it and send out the checks. We also, all agencies shall have a local board. That's in the law, and we'll talk about that in a minute. The pension law under ASRS Title 38 sets forth numerous responsibilities in 38847 for public safety, and they have to have a joinder agreement and actually come into the system, so it's governed by the laws of the land. That's why local boards are established. So if there's 250 entities out in the state of Arizona, we're just the clearinghouse, if you will, for those agencies for payments. Section 38 says you have the powers to discharge your duties. You must receive and request all information from the employer and the member for administration of the system. In other words, you are the go-to person, the local board, and the local board secretary for all communication that goes back and forth. You distribute the information received from the Board of Trustees. In other words, you should be reviewing that in your board meetings, like your actuarial report, the annual reports, all these newsletters that we send out. All of that should be discussed somewhere at a local board meeting so everyone's up to speed on what the law have changed. Furnish the Board of Trustees, the employers, the annual reports like minutes and budgets as well. So there's reasons set up in the law that the boards are established. And if you're not doing these things, we encourage you to start doing them now. Okay? So with that said, it also says that you receive the actuarial evaluations. Now, how many of you, just by show of hand, this last year or within the last 2 years have looked at an actuarial report? I'm just curious. Have you ever looked at one? Okay. That's your duty and responsibility as a board member or board secretary to review the actuarial reports. And we're going to show you where those are on the website in just a minute. Receive, not only to receive a report on the financial condition, disbursements of the funds. In other words, you need to know what our investments are like and how we've done those investments and what that percentage of return is. All of that's in the information that we send out on a yearly basis. And the board really should review that because you need to be up to speed on where your system is at. Now, every local board has an individual employer rate. In other words, your rate is tied to the membership of your group. And that group is then determined by the retirements that you have, how many active you have, and how many retirees you have. And also, another reason you are able to do this is you can appoint a medical board. Now, what that means is you appoint a doctor to review the things like a disability and that type of thing. So the board's responsible for all of that and the costs that are involved with that. So it also says that you could determine the eligibility and questions of service credits and the amounts. In other words, you determine when the person starts, you determine when he ends, and make sure there's contributions during that whole period of time. You prescribe procedures for filing applications for benefits. That's what you probably spend 90% of your time doing, I hope, is approving benefits on a local board level, because our office cannot pay those until we see the minutes of the local board and the application that you have approved them. Does that make sense? Okay. And also determine the rights of the claimant to not only the benefits for the application, but you could be sued or actually be sued for the things that are set forth in the law. A lot of board members don't like to hear that, but if you're following the prudent man rule, you probably won't get sued if you follow all the instructions we talk about today. All right? Let's go ahead and talk about the composition of the local board, and we'll take questions in just a minute. You know, there's different groups, political subdivisions, state agencies, fire districts, corrections officers group that are appointed by the governor, and we'll go through each of those individually. So if you're a political subdivision, in other words, you're a city, we'll say in this case, the city of Phoenix or the city of Scottsdale or the city of Tempe or whatever the group might be, the mayor or the chief elected official or his designee, as approved by the governing body of the board, will be the chairman of the local board. So that's number one. That's the first person that's on the board. That chairman is established through the law if you're in this group. 2 members are elected by secret ballot that are employed by the appropriate employer. In other words, you have 2 members of the board that sit down and they have a secret ballot with everybody in the organization, and they are elected for usually a 4-year term or a 2-year term, and we'll talk about how we stagger those in just a minute. Also, there's 2 citizens, one of which may be part of the merit system. They exist in the group appointed by the mayor or chief elected official, but they have to be approved by the governing board. And that's 2 individuals that are appointed by the mayor, we'll say in this case, if that's what you're looking at. And the 2 appointed citizens shall serve on both boards if they'd like, or the Indian community for both fire and police. So you have 1 chairman, 2 appointed by the board, and 2 elected officials from the membership. Is that clear? Now that's how the board should be established. Now in the corp situation it's a little bit different, right? It's usually the governor will appoint the individual who will be on the board, and then you decide who's going to be on the board as well as the chairman, and then you go through that process. But you always should have 2 elected officials, no matter what, from the membership. They have to be contributing members, active members, sitting on the board as well. Now, if you look at the state agency like the Corp or the other ones, there's usually 3 citizens appointed by the governor, and each state agency shall elect the chairman, as we just mentioned, and then you move forward with that group. Now, what happens if the governor does not appoint these 3 citizens? Then we need to go down to the governor's office and the appointment committee and make sure that happens, because you should always have a 5-member board, in this case 3 from the governor's office and 2 from the elected officials group. Or 2 elected from the membership, excuse me. All right, now if you're part of a fire district, like we'd mentioned here, a group from the fire district, it's pursuant that the chairman of the fire district is the chairman of the board. 2 members are elected by secret ballot from the membership in the fire district, and 2 citizens are appointed by the chairperson, one of which represents the fire district and maybe have some personal administration skills and a resident in the community. So these are kind of the laws of the way the local boards are set up today. And it has to function this way because that's what's in the statute, and that's how it should be, how we operate. Now what we want to do is open it up for questions at this time and see if specifically if a fire district has a question about how the board should be established. Does Corp have a question how it should be established? Any representation here? Is your board set up that way? Is yours? What's that?
Said
Finally.
Yeah, we got appointments in finally. So.
Okay, so that's what needs to happen. That's good. And how about yours?
I don't believe so. We have two members who, I'm sorry, I forgot the microphone. I believe we have to get several personnel appointed by the governor. That
Right.
part we need to do.
Okay.
But there are people who are voted in by the
The membership.
contributing
So you have
membership.
at least the chairman
Correct.
and the two elected individuals.
Correct.
You know, from the membership, and then two more appointments from the governor.
That's correct.
Okay, so let's work on that,
Yeah.
because that's important to stay, you know, within congruent with the law
Mhm.
and compliant with the law.
Correct.
Okay, good.
Don,
Question?
I have a question.
Go ahead.
Working for the airport authority and being
Right.
their local board secretary, we have 3 members of the board who are appointed by the governor.
That's correct.
So it's 3, not, I was a little confused when you said 2.
Well, 3, when there's a, if it's by the state.
Okay, so yeah, we have
State
3
agencies.
appointed by the governor and 2 that were elected by
That's
by
correct.
the members of the fire and the police.
Right,
Okay, all right.
so you're right on target.
Okay, good.
And then the secretary is appointed by the board.
Yes, and that would be me.
Lucky you, huh?
Don, you mentioned
ahead.
that board members have the potential to be sued.
Yes.
Does that involve personal liability, or is there any coverage that's?
That's up to the employer group to have that. We don't get involved with that. But mostly, if you follow the rules,
I understand.
then a prudent man rule would say you follow the rules and you'll never get sued.
Yeah, but people sue anyway.
That's true. That's a possibility, yes. You might want to check with the employer what coverage they have in that
Thank you.
situation.
So
Any
Don,
questions from the group? Sorry, go ahead.
I actually have 4 questions here, but they're
Okay.
all related, so I'm going to read all 4, and I think you can answer them all at once. Who would be considered a chairman of the fire district? Can you give an example, please? Can the clerk of the fire board be the chair of the local pension board? And then, so the board chairman of the fire district needs to be the chair of the pension board as well? Our board chair is not on our pension board. Our fire district clerk is on the pension board rather than the board chair.
Okay. So the law used to be that the clerk could be the chairman of the board. So a fire district is very straightforward now. It's either the chairman of the fire district, or he can then appoint somebody to do that position. And he's usually appointing the clerk of the board. So they have the authority to do that as long as it goes through the fire district. And but technically, the law says now that the fire district chairman should also be the chairman of the local board, or he can appoint somebody to do that. And that is absolutely right. That in this case, he maybe have appointed a clerk in that situation. Okay? That's a good question. The law used to be that way, that the clerk had to be the chairman of the board, but now it's not that way. But we have a lot of groups that are still functioning that way, and that's okay as long as the chairman has appointed them. Welcome.
Hello.
What we'd like to do is talk about the term and how long a person should serve on the local board, and make sure that they're taking the oath of office. A term of office is usually within the system of the employer, and these appointments and elections shall take place as following. One elective and appointed board member serving a term is usually for a 2-year period. The other board member is serving a 4-year term. That way, not everybody's leaving on the same day. So if you have everybody leaving in December 2017, you need to stagger those responsibilities so not everybody leaves on the same day. They should be leaving in every 2 to 4 year cycle. So you're not turning the board over every time December 2017 rolls around. Thereafter, they can serve the vacancy and be filled by the term of the 4-year. So in other words, the example would be if you were elected to the board recently, you'd serve for a 2-year term, or 4-year term, and your counterpart who is elected as well, if you're elected from the membership, would also serve a 2-year term and then do a 4-year term after that. That's the best way to do it. Now, if you're not doing it that way, I would just say flip a coin, let us know what the term dates are so they don't all leave on the same day, if that's where you're at this point. Does that make sense? So you want to make sure somebody's leaving maybe 2018, 2020, 2022, kind of stagger their term dates. And then make sure you let us know in the office, because we like to make sure you're compliant in that area. If you are taking an oath of office, each member of the local board within 10 days after the member's appointment or election shall take the oath of office. And this is also on the website if you don't have a copy of it. The member shall diligently and honestly administer the affairs of the local board, and the member shall not knowingly violate or willingly permit to be violated any of the provisions of the law applicable to the system. If you follow this statement as a board member, I guarantee you, you're not going to get sued. But when you do get sued, or if you were to be sued, is because you and 3 other board members got together and had lunch, and it wasn't noticed, and you talked about somebody's disability. That's when you're going to get sued. Does that make sense? So you can't have a congregation meeting and not have it noticed, and it has to have an agenda, and we'll talk about that in a minute. Local board powers and responsibilities. This is kind of an interesting concept because you've been vested through the law to decide all eligibility of service credits and determine the amount of manner and payment of any benefit in the system. Now this is your main duty. This is somebody who's worked 20 years, 25 years, the guy gets retirement, you do the calculation, you send it in. Those are pretty straightforward, aren't they? Those should be on your agenda. Those should be pretty easy to do now with all the tools that we have available to the local board portals. You prescribe the benefits of the claimant and make sure those benefits are claimed. In other words, you may have a disability that comes before you. He makes a claim. Your board has to meet within the 90-day, 60, 90-day rule and receive his application and make a process of denying it or sending him to an IME or reviewing the medical evidence. Make a determination of the right to claim benefit afforded to the claimant of the Board of Trustees or other rights of rehearings and origination determination. In other words, you may send an application to our office and we may review what you've done as a local board. We're just supposed to review it by law and ask if there needs to be a rehearing, or we'll approve it and say, let's move it on. It's that simple. And we'll talk about that more in just a minute. The powers and responsibilities is to request and receive from the employers and the members such information as properly administered, forwarded such information to the Board of Trustees. In other words, if you have information and you need to send it to the Board of Trustees, send it through the mail, certified mail, and we'll respond to it accordingly. You distribute any information that needs to be given from the Board of Trustees. In other words, there should be a two-way communication. Information we send to you, you give to the board members as secretaries, and also information that you send to us, we look at as the claimants. Does that make sense? So it should be a two-way street on the communication side of things. Another responsibility and power is to furnish the employer and Board of Trustees the legislature upon request. Any such annual reports. All of those are posted on the website. We're going to take a minute and look at some of those. Receive the actuarial evaluation. If you don't know where to find it, we're going to show you that in just a minute as well. And receive the financial condition and distribution from the Board of Trustees. All of this is done every year. It's like a cycle. The board should meet. Every board meeting once a year should review the actuarial reports and at least look at the financial status of where your fund is at and your individual employer account is situated. Another one would be to appoint a medical board. That could be, in this case, we're talking about appoint a doctor, not a board. In other words, not 3 or 4 doctors, but usually some person that you can trust as a doctor to review applications. The doctor has 2 purposes within the system. The first is to identify any physical or mental condition that existed prior to the membership date for which that person may apply for a benefit, and to evaluate accidental disabilities. So do you guys have a doctor you use or somebody who's working with you guys? So you got one? Do you know what we're talking about here? Okay, so be thinking about looking at, sometimes you have to go to the internet for a specific person, but everybody should have a pre-physical before starting and identify any pre-existing conditions, and we'll discuss that as we go on today. And you guys have a doctor or somebody you're working with? Okay, so it's good to have a doctor that you can kind of send somebody to that has a specialty. Now, if you have a disability, you can't always do that because he might have a shoulder surgery and have a real problem with his shoulder, and your doctor's not qualified to evaluate him. So you'd have to have a specialist in that case for a disability application. Does that make sense? But for a standard routine physical prior to somebody being hired you should have somebody that you can send them to identify the pre-existing condition. That's usually done through the new hire process. So the powers and responsibilities, as we said, you could be sued, but if you follow the protection of the board, an individual shall be indemnified from any assets of the employer account if the fund against him and liabilities arising for any reason, failure to act, if you make it in good faith, that's the prudent man rule, if you do this in good faith, you will probably never have to be sued in that situation. As long as you, but if you do it outside the law, then you have no protection. So follow the prudent man rule, do it in good faith, and you'll be in good shape. Okay, does that help you?
Yes.
And of course, you're not going to do anything outside the law.
I'd also like to hear a little more, when it's appropriate, about communication between board members
Okay.
and, what is inappropriate so that we don't make those
Okay,
mistakes.
let's talk about that for just a second. That's a good point, because what happens is you can't congregate and make a decision without open meeting law saying you have an agenda, and then you have your normal agenda items, and then you move forward. So the three of you can't get together and say, hey, what do you want to do about this guy's disability outside the meeting? That cannot happen. That's going against the law. Emails can be sent individually to board members. If it's collectively, it becomes public notice, and it needs to be noticed that way. If you guys get together for lunch, I know we have board members for the Board of Trustees. If they get together for whatever reason, we usually notice it to let them know that they're there, but not to make a decision. But they are congregating at the same location. So that makes it kind of, you're covering yourself, and you just put that on notice as an agenda, and you're covered by the law. But when you get into a meeting, you can only talk about things that are on the agenda, and you have to go into executive session if you want to kind of close the doors and talk about something that's on the agenda. It might be a disability, it might be something you need to talk about that everybody else doesn't need to hear.
Yeah, I was going to ask that question as well, but we'll jump to it now.
Okay.
And that's, when is an executive session required, particularly in cases of evaluating a disability claim, so that, again, a mistake is not made in
It has to be
public?
on the agenda as you're going into executive session to discuss this disability. Now, needs to be a reason to go on the agenda. You can go into executive session any meeting you want, as long as it's put on the agenda and as an item that you're going to move into an executive session. That's when, so it can go, as long as it's on the agenda, you're okay. But when you get into executive session, you can't discuss anything that's not on the agenda.
All right, now, what I'm thinking of is the person requesting the disability retirement is in the room, and there are other members of the public in the room.
Right.
And the board is going to have to be discussing medical issues in order to arrive at a determination.
Then
So you got a
go into
HIPAA
executive-
problem, don't
You go
you?
into executive session. for
Okay.
that. Correct. Good point. I see what you're saying.
In fact,
And as
you
long as
must-
it's on the agenda, you're okay.
You must go into executive session if you're discussing personal medical information.
Right. Yeah, because just HIPAA laws protect him from talking about his situation in the public. So anytime you have a disability, it's always a good idea to have that an executive session scheduled so you can go in and talk about it. Okay, does that make sense? All righty. Follow the rules, you won't get sued. A local board shall from time to time establish or adopt certain rules. Each member of the local board is entitled to one vote. A majority of the vote is done by the membership. 3 members need to be present at a meeting if a quorum of a meeting is to be established. If you don't have 3 members, you cannot call the meeting to order, and everything will be automatically moved to the next agenda. So we had some board minutes we read, and 2 members of the board are there, and one's on the phone. Is that okay? Absolutely. As long as 3 or 4, or we encourage 5 always to be at every board meeting. So that's kind of how that's set up, and we're going to go through an example in a minute. You'll have to make decisions to deny or approve every action item on the meeting agenda. The only way around that is if you get to an item and you don't have enough medical information for like a disability, you just table that. Don't take any action on it. If you see something that's on the agenda, just do not take any action if it needs to be tabled. If you have 3 members at the meeting, 2 of those members need to vote in favor for the issue to have a ruling. There's 2 to 1 actually passes in a board meeting in this situation. We always encourage 5 at the meeting, because then the employer's represented with 2 representatives, the employee's represented with 2, and sometimes the chairman will be a tie vote depending on the situation. Okay? So what I want to do is take any questions at this time and then move on to an example on the website. Go ahead. Thank you.
This goes back to terms of the board members.
Okay?
And at the authority, we have 3 members from the authority membership who are
Right.
appointed by the governor,
Right.
as I stated before. It's the same 3 guys, but they've been serving in holdover status since 2012.
They can do that.
Okay, we're trying to get the governor to appoint them, to approve their applications at
Right.
this point, and we're having trouble with that. So my question is, at what point do their terms become effective so that we can do the staggering date, the staggering terms? and
Whenever
things
the
like that?
governor appoints them, then you can stagger the terms at that point.
But not until then, even if they're still
Even
serving
if
in
they're in a
holder?
holdover situation, that's right.
Okay.
Because they're in a holdover until the governor appoints them, then you can stagger their terms going forward with a 4-year
Okay.
term or 2-year term.
All right, thank you.
Okay, so what I wanted to do is talk about some other things that we just reviewed on the website now. Model uniform rules. We just talked about that. Do you know where to find it on the website now? Under the employer section, follow down, model uniform rules. 38-847 for public safety, and the other one we just pulled up for court. Yes?
That question regarding the fire chief troubles me a bit. The fire chief, you can call him a civilian, or you can call him in a meeting like anybody else, member of the public, but in truth, he's member of the administration. And
Right.
seems to me the pension board should be independent of the
They are.
administration, and therefore, it would either be a conflict of interest or the appearance of a conflict of interest to have the fire chief directing anything, particularly to have the fire chief participate in an executive session.
That's a true statement. So they're usually not invited into the executive session. All right. Any questions about the model uniform rules? How many of you have actually looked at those before or read them? Okay, so that's something part of your homework assignment. Let's go back, look at those, read through them. It'll help you, stay out of trouble and be sued. Let's talk a little bit about hearings now. Hearings before a local board could go before the Superior Court. The court can then send orders back. It's a very clear direction. They rarely give anybody, tell us to give them a pension. Decisions to the local board are subject to judicial review. In other words, this is where a person's made application, you've denied it, we've denied it, they can still go to the Superior Court and get another opinion. Now, what do you think they're going to look at when they come back from making a ruling on this determination? They're going to go right back to the executive meeting minutes. That's what the court system will do. So you better have that notated and well documented. We never want a copy of your executive sessions, but you have to keep them on record in case the Superior Court's going to want them at a later date. Okay? So when making that ruling determination, the local board shall be entitled to rely on the information furnished by the employer, trustees, independent legal counsel, and the actuary of the system. These hearings or rehearings are always done not out of, we just want to make sure we're protecting the rights of the member and protecting the fiduciary responsibility of the fund. If you do have a rehearing, any action or majority of the vote of the local board which is inconsistent with the provisions of the system shall be final. It's conclusive, binding on all persons. You have to have the rehearing or appeal within that 60-day window. The claimant of the Board of Trustees may ask for a rehearing, our office, before the local board, and that 60-day window will start as soon as we've sent you a letter, or you sent us a letter, certified mail. How many of you have actually had a rehearing before? Okay, what would the reason be for a rehearing?
A disability retirement, and the individual wasn't notified in writing in a timely manner.
There you go. So that's a good example. You got to follow the rules to say, I'm going to notify the member that we're going to have a, whatever the rendition of the decision was. So those are just little things that we would look at. We never want to overturn anybody's decision. We just like to review what you've done, agree or disagree, and ask for a rehearing. That's all the process is, yes.
In the event that there's an appeal to the Superior Court, you've indicated that the Superior Court is going to want and probably rely on the minutes of the executive session.
That's correct.
But is there any requirement or expectation that the chairman of the board or the board as a group supplement that with any written brief?
Oh, absolutely, yeah. They'll ask for a brief, they'll ask for that, but the last one we had, he went straight to the executive session minutes. So you can't be talking about things in the executive session you shouldn't be talking about. Okay? So yeah, they'll ask for the brief and the explanation and then the executive minutes, because they've already seen the board minute results. You've denied him usually in that case. Okay, another rehearing situation. The applicant or claim receives notification from the local board. If you don't send it by certified mail, that's when we ask for a rehearing. You have to take action receiving benefits or not receiving benefits, whichever occurs first. And if you have this notification going through the local board, if you always do it by certified mail, you can then always be sure that you're covered by the law. But the member has to be notified of your decision, whether it's a yes or a no. Okay? Rehearing may come up if the member's responsibility to provide all the evidence for the local board to take an action on an issue. In other words, we've had local boards who've received an application for a disability. They've gone through the process, they've looked at it, and there's insufficient medical evidence based off the doctors they've listed. You table that discussion, ask the member to provide additional documentation, especially on a rehearing situation. If there's no new medical evidence, what do? Deny it or move forward, table it again. Okay? If the local board's responsibility to notify the member of all actions by certified mail, the 60-day time limit will not begin until the notification is made, and the 60-day window could be extended indefinitely if your board fails to notify the member. In other words, the member has rights to know what the board has decided. That's basically what we're talking about here. So we have a question from the webinar.
Are all official communications done solely via certified mail, including the minutes?
Yes, that's what the law says.
Excuse me, is that all communications to the Board of Trustees and to the member, the claimant?
Yes.
Okay.
That way you're always protected that way, because you know you've got a receipt, you've got everything set up. That's the way the law reads now.
Okay, thank you.
Okay, any other questions from the group today? This has been a good discussion so far. Anything from the webinar? If not, we'll go ahead and move forward then. Let's talk about what should actually be on the agenda and what the content of that agenda should be. We believe that all new members in the system should be put on the system on the agenda. You should take a list of every name taking the medical exam. List those with pre-existing conditions, but you don't necessarily put what the pre-existing condition is. You just put Joe, pre-existing condition. That means we know in the minutes of the meeting that you've notified him by certified mail that he cannot apply for disability for that reason, and then move on. But everybody that has to take a pre-existing condition exam prior to starting with you. List of names not taking the exam offered. We don't see that very often, but sometimes the guy says, I refuse to take it, and he doesn't get a pension on a disability because he's refused that pre-exam. On your agenda, you should always have a disability application. There's accidental, which is job-related, ordinary, which is non-job related. You may have a death of a member, he's still on the job, he may be retired, and normal service retirement applications. All of this should be on your agenda every time. If you don't have it, just take it off the agenda and put it on the next time. Make sense? Okay. What else should be on the agenda? You should have the annual review of any disabilities you may be looking at for return to work. Your responsibility as a local board is to look at any survivor benefits. If there's a spouse, an eligible child, a guardian, any refunds, quits, fired, anything that has to do with money within the system, you're supposed to have on the local board minutes approving that they've moved on in their situation. And then any review of information, as we talked about the actuaries or our newsletters that we send out, all of that could be reviewed as an agenda item. Another agenda content may be the expenses of the board, board training meetings and seminars, cost of any attorneys, independent medical exams, pre-hire, disabilities. All of that could be part of your agenda content. Hearings and rehearings, service purchases, military time, drop applications. The list just goes on of you are responsible to make sure the claimant has the right to his benefit. Okay? Other agenda contexts, you might have future agenda items, report of elections of public safety positions. You can put in there, Joe was elected to a 4-year term, and this is his term date. That's what you can put that in the minutes as well. Any approved minutes from previous meetings, new business, call the public, and close the session. Pretty straightforward. Any questions about what should be on the agenda? We'll talk more about that in the second hour. No questions? If not, we'll go ahead and move on. Disability applications. We want to spend a few minutes talking about this because a pre-existing condition determines if he has the right to make application for disability during his career. A pre-existing condition, the board must hire a medical doctor to complete the exam. This exam should look for any physical or mental condition of an injury that has existed prior to the member's date of membership. The board staff then must review that physical exam, usually not in a public meeting, and then you should also notify the member and identify those conditions. You send them a letter stating, hey, we know that you got hurt with your knee in your football injury. You cannot apply for a disability based off your knee injury from football when you're in high school, whatever you want to put on the agenda. Okay? But if you don't notify the member, it's pretty hard to come back and say, hey, he can make application for that. Pre-existing conditions, it protects the plan from any non-qualifying disability application. In other words, you're not opening the employer's checkbook to let everybody out on a disability. That's why you do a pre-existing exam.
Don?
Yes.
Question about the pre-existing. If the member does not reveal the pre-existing condition and the doctor does not become aware of it in the medical exam, and later the claimant wants a disability retirement based upon what we now know is a pre-existing condition because we pulled medical history and we see that there was a pre-existing condition that had not been revealed, how's that handled?
That's handled by the board in executive session, what direction you want to go. Because that's a touchy situation because you don't know if he did or didn't actually disclose that to the doctor. That's why you have to usually give a doctor a series of questions to ask those questions, so then he's covered. The doctor's covered to say, yes, I asked all the questions, there's no pre-existing condition. If you don't like what the doctor's results are, I get a new doctor. See what I'm saying? Yeah, it's a touchy situation. That's a board decision at a later date.
Okay.
Because you don't know if he did or didn't disclose it. You have no idea. So it protects the member to make sure they don't qualify for disability, that they had back problems prior to that. You want the doctor to find all pre-existing conditions in the medical records and notate that in the member's file. And your board should meet and approve those, and the doctor report on all new hires.
Say, Don.
Question from the webinar.
When hiring employees who transfer from other fire departments, does the hiring agency receive a document of pre-existing condition from the previous employer?
If they request it, they can.
And then what happens to the liability? Does that stay with the previous employer?
No, it stays with the employer who hired them. So there's no good news if you haven't been, there's some good news if you haven't been doing it, start doing it now. We talked to a group once and they said, we've never done a pre-existing condition exam. And we said, well, you better start now because otherwise those guys could all go out on a disability. Now that's a good question that came up from the webinar. Usually you're under the PSPRS umbrella, but you still have the right to ask, do you have any pre-existing condition coming as a lateral transfer from another employer, and have them do an exam if you want to. But when you hire somebody, you assume that with responsibility and liability, and you need to know about that. Any pre-existing conditions, good news, the local board can start using an employer physical to make those determinations, but the employer cannot use the local board exam for hiring purposes. Some people do for like, If you're doing post-certification for police, they use the same exam, but it's not a good idea. It's good to have one exam for that situation, and all local boards must acknowledge the receipt. These are confidential medical records. You cannot discuss them in public meeting. So the board doesn't necessarily need to see all the reports, just be confident that staff is checking that and listing that as the board secretary and human resources or whatever the situation might be. But I like to beat this a little bit longer. The medical board can be composed of a designated doctor, usually a panel of doctors. But if the purposes are determined in the disability, you cannot use the same board and doctor panel for the disability. It has to be a new person seeing this for a disability. In other words, you have a guy seeing him all along. He should be an independent medical examiner after all the medical evidence has been brought in. Is the employee required to take the exam? Actually, the answer is no to that. But if they do and do not take the exam, they've waived all their rights to the disability. Most of them are not, most of all the employers require an exam anyway. The AZ post for police, as we just mentioned, and the new hire medicals is your best way of doing this because you have statutory rights to ask for a pre-existing condition. All right. We'd like to entertain any questions from anybody in the group now. Have you ever had a problem with this before? We'd like to know about it. But it's better to just do the pre-exam, move forward, then you've got it documented, send him a certified letter. Question from the webinar.
If a member is injured in the line of duty at employer A, do they still qualify for disability retirement under employer B's pension board, even though that is technically a pre-existing condition?
I'm not quite sure I understand that question.
So they're with one employer, they get injured, but then they move to another employer. That second employer then is asked to grant a disability. Is that a pre-existing condition?
No,
of the
because it's
injury
under
at
the
A?
PSPRS umbrella. In other words, if he had the pre-existing condition prior to his hire with the previous employer, then he can't apply for it. But if he got injured with employer A and you hire him to employer B, he's still under the PSPRS umbrella as a lateral transfer. That answer the question?
So he could receive a disability.
He could receive a disability if it merited it. But he has to know that he's coming with that liability coming to him, that new employer. That's a good question. We do have a lot of employers, even though they do lateral transfers or hire from somebody else, they still require the guy to go through the exam so they at least know about it before they hire him. All right, let's look at some things to do and consider. We have meeting notices, agendas, executive session, minutes, staff, legal, and some advice for you. And then we'll take a break. You must be posted a meeting notice for any agendas 24 hours before the meeting takes place. It's required by open meeting laws, and the same rules apply for a public meeting. That's just in the law, okay? We had an employer call up the other day and said, our meeting's tomorrow at 11 o'clock, and they're calling it 2 o'clock, and we want to change the agenda. Can they do that? No. It has to be on the next agenda, okay? The agendas need to be clear. If you forgot to put something on the agenda, do not take any action because you cannot do that. It has to be discussed in a new business and placed on the next agenda. If you need to go into executive session for an issue, you must have it posted on the agenda before it occurs. You must mail the meeting notice and the agenda to all members who are impacted so they have the ability to attend the meeting if they choose to do so. The member has rights to come to that meeting, okay? The executive session, you don't want to do it usually without an attorney. You should always record it, and this is the area where the board could be fined $500 for each occurrence for talking out of turn about things that are not on the actual agenda. And I could see how the Attorney General's office could go in and listen to your minutes and find the person. You can't be talking about something that's not on the agenda. The minutes, let's talk about that. Record your minutes, make a brief electronic copy of them. You must send these to the Board of Trustees, as we talked about this communication earlier, within 20 days, signed by the chairman or the board that they were ready to go and the minutes are approved. The local board must take these minutes during the executive session and include actually what takes place and what was said, and keep them on file. Do not send them to our office. We always get a question at this point to say, how can we send you minutes 20 days after the meeting happens? They're not approved. That's correct. Send the draft minutes in, and the next meeting approve them, and then send the next set of draft minutes and approved minutes. So we can have a cycle of what you've approved at that time. Because we cannot pay a benefit unless you send the draft minutes to our office. Okay? So it's kind of a little bit of a cycle of keeping your minutes up to date and sending them in, and then we'll be reviewing those by each retirement. Minutes on the disability. If you get granted disability, send the minutes in as soon as possible. Put draft at the top, especially. You can send a letter from the board stating you've approved the disabilities. The minutes will be coming later. But by law, we cannot pay that disability unless we have notification from the employer. The notification on disabilities always should be sent by certified mail. Let's talk about the local board secretary, because we have a few secretaries here today.
Say, Don, before
Okay.
you move on,
Okay, question?
must all the meetings be recorded, and should we audio or video record meetings to avoid errors or discrepancies in our minutes in order to ensure transparency? And for how long must the recordings be kept?
Okay, that's up to the employer and the local board, how long they should be kept. We have a lot of boards that record the minutes and then transcribe the minutes to us off those things. We don't need to see the prescribed minutes that are videoed or recorded. You should keep the executive session minutes under lock and key at your location because they are confidential. And we don't want to see anything except the typed minutes. And it doesn't always have to be so verbatim. We want to make sure all the action items are on there and properly documented, and who's retiring and what the amount is, his retirement date. Those are the types of things we want to see on the minutes of the meeting. If you're a local board, you should take these minutes, process the application, the agendas. You board members can be involved in that, but staff usually does this function. The bigger the agency, more responsibility there might be. The local board staff may be an HR person or somebody in personnel. Depends on how much work there is for each group. There are some fire districts that only have 5 employees, and usually it's one of the guys on the staff that's one of the secretaries.
Hey, Don, I do have a question. Being from the state agencies, are we subject to the retention schedules?
Yes, you have retention schedules
for
for
these
keeping
areas.
that information based off of what the retention schedule is for the state, or as the employer is contracted to do so.
Thank you.
If you don't have much on your agenda, you might want to avoid the expenses. You don't always have to have the attorney present for legal counsel. But don't be a penny pincher. If there's something that you think you've forgotten, or you have a disability that's questionable, it's always good to have an attorney present at those meetings. So a little advice for anything but legal counsel, you can always call our system. You can talk to the Phoenix local board. They're very good at helping people out. Sister boards that are in your area. Local boards can always talk with each other, help each other out as well, and look to your sister boards to handle a lot of the crazy stuff that's going on sometimes. It's always good to get together once in a while. Question from the webinar?
So Don, who funds the local pension board's legal fees?
The employer through the local board, whoever that employer might be. Should be a budgeted item going forward. Any other questions at this time? All right, what we'd like to do then is go ahead and talk a little bit about the summary of statutes and get into some new things that are applicable to the local boards. The summary of statute says the local board shall adopt the bylaws. Where are the bylaws? They're in the model uniform rules. Everybody knows where that's at? You should be able to find those now. Elect a secretary, may or may not be a member of the local board. Usually we recommend it's not, if that's possible. The secretary of the local board shall keep the records, send them to our office within 20 days, and forward all communications to the Board of Trustees from your local board. We like to get information from your group. Just like, how many of you have seen our newsletters? We like to send out newsletters to your group, keeping you informed of what's going on here at Public Safety. Those can all be on the agendas as well. The fees of the medical board and of legal counsel and all other expenses of the board shall be paid by the employer. Answers the question we just had. The local board shall issue directions to the local board, to the Board of Trustees, but all benefits are paid from our office once you have approved them, but not until then. Local board shall keep on file all of the all the proper medical information, all the actuaries, Board of Trustees. In other words, you should have a file at your office for each one of these individuals who's retired. You should have a file for anybody who is on the local board and had the oath of office. You should have a file for all of your minutes that you keep in your own office. All of that should be documented and organized. Any questions up to this point? All right, what we'd like to do then is talk a little about the resources we have available and talk a little bit about some resources as well. The Arizona State Statutes for Public Safety is 38847. You can always go to the website and see any changes that have affected the local boards. Recent implications. There's a couple things we'd like to talk to you about. The Hall-Parker case is the first one. As you know, there was a lot of distribution of money that came from our office that went out to all the employers. That was distributed to those who by law should receive it. The interest for the elected officials has been determined and received by the employees at this time because it's been calculated by the court. But the Parker case has affected all of the public safety individuals, and that has not been determined by the court as of today. We will notify all the employer groups once that's been determined, but at this point we're hoping all of the principal has been returned back to the employers going through the employer payroll system and how you distribute it. Does anybody have any questions about that? That should be pretty much tied up, except the interest portion, which we don't know at this time, but we'll communicate through a newsletter as soon as that's been determined for the Parker case. Okay? Any questions about that? Not? Let's go ahead and talk about the next thing that's impacted the local board. The new contribution reporting requirements. In other words, when the employer groups are making contributions to our office, there's a new set of rules. We've had webinars, seminars, and things like that, and we're upgrading our employer payroll site, and that will be released fairly soon, and we've been increasing the local board portal site. That will be released later this year, and but there are some new reporting requirements that the employers need to know about. Any employer payroll groups in here today? Nobody has any big questions about that? Anybody from the webinar have any questions?
Are the payroll departments notified when we send the notice of who's administrator or payroll or accounting director's office? Do you guys send them notices as well so that they know to?
Yes, it's what's going to happen as we go forward. Right now, they send a membership form in if it's a new employee. Okay, that's put in the database, and then contributions come in against that. As the employer payroll site's going to be calculated and move forward, or released, they're going to be able to put it in what's called the demographics file right on the website and make contributions through there.
Right, what I'm saying is, do you guys, as all this new, the new ways, that are coming,
Yeah.
and any training that's available for our payroll department, are you guys emailing them directly?
Yes.
And, okay.
Yeah, all the payroll groups should be contacted as this new employer website's being released. Unless Dave has another comment to that.
And for the state, is payroll each department, or is it the state in general, like the general accounting
It's usually the
office?
general DOA, ADOA,
ADOA.
and all that group that's being sent through, yeah.
Okay.
Okay? But I know each employer group has now sent in a demographic file that's being reviewed by our office, and they should be able to, within a few weeks, make contributions to those employees. I don't know, as it moves forward. Okay, good point. All right. Employers must now post your funding ratio on your website. Did anybody know that? In other words, you need to go back and make sure your employer is posting the funding ratio on your website. That's new law, and we'll talk about that in a few minutes also. But I want to make sure you understood that's some of the impacts to the local boards, the employer groups. That's just in 1442, I believe, the law was changed there.
Okay, once again, coming from a state agency, is that posted on each agency's website or through the Department of Administration's website?
We were told that it could be both.
Both, okay.
I would be safe and put it on your employer website. That's new this year, starting in August. All right, any other questions from the webinar group?
And you're talking about the external website, right? Not just the intranet.
That's right, the external website, that everybody can see it. Let's talk a little bit about some tools and resources. We have the local board training section on the website, which we looked at just a minute ago. We're going to go to that next. The training schedule's out there, our newsletters, we have videos. You can always go to psprs.com and look at that information. Tools to help you process a retirement. You remember just looking at the retirement instruction manual. There's one that's prior to or after, depending. The retirement spreadsheets we just looked at on the website as well. All of this is encompassed so we can make your job as a local board or local board secretary easier. Resources for your members. We have members' handbooks we looked at on the website for Public Safety Corp, members only website, and the YouTube page and Facebook page as well. So this members only website is in development and should be released fairly soon, where the member can actually go in and look at their records, and that's being developed to help them make their choices as this new process rolls out as well. Any questions from the webinar or from the audience at this time? So we have myself as an employer local board relations manager, which we've done a lot of training, which is out on the website as well. We've got active members, LaDawn Toger, who's always willing to help if a new member gets involved, and she's very good at helping make sure the contributions are coming in. We've got Bonnie Brown in the retired members group, who helps process the retirements, and you may have worked with Tara or you may have worked with Joanne in the past. All of these individuals are here to help you make sure you're following your fiduciary responsibility. So we wanted to thank you for attending this section of the webinar and this section of the presentation. We're going to take a 3 to 5 minute biological break, and we'll be right back.